This conference will now be recorded.
Hello, and thank you for joining us for this presentation on the COVID-19 workers' compensation presumption that went into effect in California on May 6, 2020. This recording is presented by RTGR Law. We are a statewide workers' compensation defense firm, also handling civil subrogation and employment cases, especially those cases which overlap with workers' compensation claims. Our firm has for years dealt with the most complex workers' compensation cases. In fact, that's what we're known for, including safety officer benefit presumptions, such as the cancer and heart presumptions. So we're very familiar with complex cases and very familiar with legal presumptions. So the complexity brought about by this pandemic and its effect on the workplace, and now this presumption of injury, are things that we're used to dealing with, and we are tackling it with vigor. For us, this is just the latest of a series of complex and challenging cases that we strive to manage for our clients and aggressively litigate when necessary. This is a general presentation. It's actually put together. Today is May 9, 2020, 3 days after the executive order went into effect. A lot of this information is brand new to all of us. We've done our best to summarize the information and provide it in this overview, but this should not be construed as legal advice on any particular subject matter or a substitute for legal services. If you do have questions during or after the program, you can certainly email those to any of our RTGR law offices. If you see down there on the bottom of your screen, there is our hyperlink to our contact page. If you email your closest RTGR law office, you will be your email will be read by our most senior attorney in that office, and all of our senior attorneys are studying this law very carefully, and we're putting our heads together so we have a uniform analysis. We can provide a uniform best advice to California employers. I'll also have those email addresses at the end of the program, and at the end of the program, information on obtaining a claims adjuster certification for attending this on-demand webinar presentation, and where you can get more information about the executive order, COVID-19, and other items. The agenda today is here on this page. We're going to talk about the executive order and its legal effect, which employees are covered by it, the limited time that an employer has to act on these claims, which is a significant item, the rebuttal of this presumption, which is rebuttable, and the burden of proof on how to rebut these claims when it is appropriate to do so. We will then talk about when is it appropriate to rebut these claims and which ones can be rebutted, which claims to accept, delay, or deny, who pays for the COVID-19 testing, which is a big part of this presumption law, the sick leave offset that was built into the order. Of course, no discussion of workers' comp benefits would be complete without discussing temporary disability, permanent disability, Labor Code Section 4850 pay, and death benefits. After we've covered that, we'll talk about the negative consequences of this bill, or I should say this executive order. The order is less broad maybe than some of the statutes that are currently pending in front of the California legislature, but it does have negative consequences, most likely for certain employers, maybe even for certain employees. And we'll talk about some of those consequences. That will be probably something that will be more understood as time goes on. And we will post, we have on our blog at rtgrlaw.com, we have a blog page, and on there we have a couple of posts on COVID-19 and one specifically dedicated to this order. If you go to that post, you can see what amounts to daily updates that we post there as new information comes in, new analysis is put together by our attorneys, questions come in from our clients, and the answers that we provide. We have all of that there on our blog post, and we keep it current, so it's a good one-stop shop. And then finally, we'll talk about what employers can do in light of this crisis to better manage the situation. So Executive Order N-62-20 was issued on May 6, 2020. It creates a rebuttable presumption of COVID-19 injury in the workplace under limited circumstances, and it's very important to understand what those limited circumstances are. Interestingly, the presumption expires on July 5, 2020, so it's legally null and void as of that day and from there on after. That is, unless the governor chooses to extend the order, or the legislature, for example, passes a law that the governor signs, basically codifying this order. That might happen. The governor passed the shelter-in-place order, you may remember, with an expiration, I believe, on May 3, 2020. Well, that expiration date has come and gone, and because the order, his shelter-in-place order, was extended because of the circumstances, that this executive order may also be extended beyond July 5th. So we'll have to keep a careful eye on that. So what does this executive order do? So basically, what it does is it changes tips the scale, if you will. Generally, in a workers' compensation case, an employee has the burden of proving injury. And sometimes that's pretty easy to do because the employee, for example, maybe there's a slip and fall at work that's witnessed by coworkers and a supervisor, and an incident report is taken, the employee is treated at occupational health, the occupational health physician does an exam and testing, and it turns out that all of it is consistent with the report of injury and the witness statements, and everything checks out, and the employee has basically met their burden of proof. And in fact, in most cases, the employee has a limited time off work, is paid for that time off, gets back to work full duty, and that's the end of the workers' compensation case. And that's how the vast majority of workers' compensation cases in California play out. Some of those cases, however, are litigated. Maybe the doctor has a different opinion about what happened, or maybe the witnesses have contradictory statements. There may be circumstances where a claim is contested. In those situations, it's the employee who has to come to court with evidence, and and has the burden of proof, which means that if the evidence is equally weighted that the injury did or did not happen, the employee will not prevail. In this case, if the evidence is equally weighted, the employee does prevail because the burden of proof now shifts to the employer. So the employer has to really tip the scale in the employer's favor in order to prevail on a COVID-19 case at work, if this presumption applies to that case. That's the basic legal effect of the legal presumption created by this order. So who is covered? This order is very broad in the sense that it covers every employee in the state of California. There are no exceptions. It's not limited to a certain classification of employee. For example, in safety officer cases, there are legal presumptions for example, heart and cancer, but that's limited to, for example, active duty firefighters and police officers and others, which very important jobs, but is a small subset of California employees. This presumption applies to every California employee, all millions of them. In that sense, it's very unique from the other presumptions and much, much broader than the other presumptions. It applies to everyone, including healthcare workers and first responders. There's much discussion, and in fact, a bill or two in front of the legislature that is targeted to healthcare workers and first responders. Of course, this order includes them, but it also includes every other employee as well. So it's much broader than even some of the bills in front of the legislature in that sense. Under the order, a COVID-19 related illness, again, is presumed to arise out of it in the course of employment. for purposes of awarding workers' compensation benefits, but only if all of the following requirements are satisfied. And those requirements are, number one, work time proximity. The employee has to have worked on or after March 19, 2020 at the direction of the employer. So employees who happen to have been retired or laid off or terminated prior to March 1, 2020 would not qualify for this presumption. Number two, there has to be a positive COVID-19 test result or at least a affirmative COVID-19 diagnosis by a California physician for this presumption to apply. It can't just be speculative. At least one of the bills, I think it's 664 in front of the legislature, is far, far broader than a positive test result and diagnosis. It would cover people who are basically who think they might have COVID-19 or a physician thinks might have it, or an employer is concerned they might have it or catch it or pass it along and they're quarantined. This executive order doesn't do those things. This executive order is limited to individuals who have been tested positive or have at least had a diagnosis. And we'll talk about the positive test result because it becomes very, very important and really key to this law. Number three, the diagnosis time proximity. So there has to be a nexus between the diagnosis, the time that the diagnosis was made, and the last day, if you will, that the employee worked. Those two things have to happen within 14 days. So the diagnosis has to be made or the positive test result within 14 days of actually having worked. If for whatever reason the employee wasn't at work or last worked 15 days before that positive test result or positive diagnosis, then this presumption will not apply. Finally, there has to be workplace proximity. The workday that's mentioned above has to have occurred at the place of employment. That's the employer's factory, office, building, not the employee's home or residence. So this law will not cover all of those folks who were early on sent to work at home because home-based or residential work, even though you're doing work, even though you may be working 8 hours or 10 hours a day from home, that work is not covered by this presumption. It has to be at the employer's place of business. As I mentioned, the verification by testing is an important part of this statute. So it's important to remember that the order requires a positive COVID-19 test result at the time of the invocation of this presumption, or COVID-19 diagnosis by a physician before the presumption applies. Now, if there's only a diagnosis by a physician without a test result, and we know that there have been some challenges for people really all across the country to get this test, but if there was no positive test result at the time of the diagnosis, and the physician, we hope, made an informed diagnosis based on scientific evidence, not just based on speculation, that there was, in fact, a COVID-19 illness, that diagnosis alone, without testing, has to be followed up within 30 days by subsequent positive testing. Now, at 30 days after the initial diagnosis, the person probably no longer has the infection, or hopefully doesn't. Most people won't. But they may have an antigen or antibody present that can be tested and verified, hopefully without a false positive. And that's what's necessary in order for this presumption to apply. So there has to be either a positive COVID-19 test at the time or positive diagnosis. And if it's just a diagnosis, that diagnosis has to be followed up by subsequent testing within 30 days. All that has to be done, or else this presumption does not apply. Now, the 30 days causes me to scratch my head a bit because there's also another 30-day window. And the 30-day window is a very, very limited time for an employer to act and deny a case if it needs to be denied. So if the conditions that we just went through are met, these claims can only be denied within 30 days of the filing of the claim form. Now, it's entirely possible that a claim will be filed because a person goes in and has a diagnosis, but with no test result, right? The doctor made the diagnosis, but they didn't get a test. Well, the employee may, within 30 days or on the 30th day, go back and get that antigen or antibody test. But then that 30 days is also the last day for the employer to deny the claim. So even if that test result comes back positive, thus invoking the presumption, the employer may be issuing a denial because they've got to get a denial out within a very short window of time, 30 days. Normally, employers have 90 days to deny a workers' compensation case under Labor Code Section 5402. But this order limits that time to 30 days for these presumed compensable injuries. So you can see how those two 30-day windows could run up against each other and cause a lot of complexity. It's possible that if the employer waits for that subsequent testing follow-up to that initial diagnosis, and that test result comes back negative, the employer may have, as I said, already issued a denial that they can stand on. But if they're waiting for that result to come back before issuing a denial, and there are other reasons to deny the case, even in the face of the presumption, they may lose their opportunity to deny the case. So it makes sense for employers, by the way, to act on every COVID-19 claim within 30 days, even if you're not sure of the applicability of the presumption. So if you're not sure that the diagnosis was accurate or satisfactory, or you can't read the doctor's handwriting, or for whatever reason you're not sure if this presumption applies to a particular individual who's making a COVID-19 claim of injury, maybe you're not sure if the person was actually physically at work or versus working from home. Maybe they may have gone into the office one day, but you're not sure. There's all kinds of reasons why you may be in doubt as to whether the presumption applies, but they have a COVID-19 claim. And even if the presumption doesn't apply, it may be a valid COVID-19 claim or not. We'll talk about that. So what does an employer do? Do you act within 90 days if you think the presumption will not apply, or do you act within 30 days because you think the presumption may apply? The simplest answer is to use the 30-day time frame for every single COVID-19 claim, whether or not you think the presumption applies, whether or not the employee thinks the presumption applies. Use the 30-day window to either accept or deny the case. Late denials cannot be undone by California employers, or I should say the circumstances to undo that are very, very limited. It's much easier for an employer to initially not deny a claim, but later decide to accept that claim. That can be done anytime, or it could be awarded by a workers' comp judge if it can't be reconciled between the parties. So the presumption shifts the burden of proof to the employer. This is a rebuttable presumption. It is not a conclusive presumption of injury. There is a bill, at least one bill right now in front of the California legislature that would create a conclusive presumption of injury, and the governor was under pressure to make this presumption conclusive in his order, and he did not do that. He instead made this a rebuttable presumption. Our office rebuts presumptions all the time, presumptions which are much more locked in stone than this one is, including heart presumptions and pneumonia presumptions and hernia presumptions and duty belt, low back injury presumptions. Those presumptions are rebuttable, and we are trained in rebutting them. And so are many employers are familiar with what needs to be done in order to do that. So the end of the day is not the question of whether the presumption applies. The end of the day is, what does the evidence say, and is this a valid workers' compensation claim or not, even in the face of the presumption? So the employer can rebut these cases if, in our opinion, the risks of workplace infection are not particular to or characteristic of that claimant's specific employment, and there was a known or likely non-industrial cause, such as an infected family member or roommate, or other means of transmission besides the workplace. So if those two things are present in a case, even in the face of the presumption, it can probably be rebutted, or at least there's a chance it could be rebutted. We'll talk a little more about those two elements to rebut the presumption, and also about how to deny these cases. So long as current medical information indicates that COVID-19 is a risk to the general population and not just to workers, some presumed compensable COVID-19 claims can still be denied and the presumption can be rebutted. This COVID-19 affects everyone. It affects, unfortunately, it affects children. Unfortunately, it affects seniors who have been retired for many years. It affects all kinds of people and every kind of person, not just people who happen to have a job. So we know that it is an infectious pandemic that is present and a risk to the general population. What this presumption does is it focuses our attention on this particular claimant, their job, and the most likely means of transmission in their particular case. How do you build a rebuttal or a case for rebuttal? If the facts suggest that the employee's particular job duties, that is the job that he or she was doing, was no more materially risky of causing contraction of this disease than would be the case for a member of the general public, then the claim should be delayed at least because the presumption may be rebuttable. So if this employee falls within a group of jobs that are not at particularly high risk for contracting COVID-19, then the claim should probably be delayed and statements taken, medical records reviewed as quickly as possible, because we have a 30-day window to deal with this, and a decision made as to whether to accept the claim or deny the claim. And some of these claims should be denied. So what are the types of jobs that are at a materially greater risk of contracting the disease than the general public experiences? Well, we don't have to speculate. We know the answer. OSHA, who has studied these things and has many, many years of experience dealing with infectious diseases in the workplace, has published guidance on preparing workplaces for COVID-19. For those of you who have a PDF of this presentation, that is a hyperlink to that OSHA publication. And included in that publication is a breakdown of jobs, all jobs really, some of which are classified as high risk or very high risk of contracting COVID-19, and the vast majority of which are considered to be moderate or low risk of contracting COVID-19. So that's the starting point for this analysis. Is the employee in a high-risk job or not? The high-risk jobs should not come as a big surprise. The employees who are at high risk or very high risk of contracting COVID-19 include many healthcare workers, doctors, nurses, dentists, pandemics, emergency medical technicians who have direct contact caring for or are otherwise exposed to known or suspected COVID-19 patients. I'll give you an example of a healthcare job that is very high risk of COVID-19, and that includes a technician, nurse, doctor who is providing intubation to a known COVID-19 patient or patients. So this medical professional is having to deal with these patients who the patients themselves are known to have the disease. They've tested positive. Because the doctor is having to intubate them or the nurse is having to intubate them, they're having to put the breathing tube in, they're having to deal with they're constantly being exposed to the breathing and fluids of the body. They're being exposed to coughing and sneezing and all the other side effects of this terrible disease. Those people obviously are at very high risk of contracting COVID-19. And even the healthcare workers who just come into contact with those folks indirectly, they're exposed to those folks in the hospital, even if it's maybe being involved in aftercare or care with that individual short of intubation, they're still at high risk because of that level of exposure. Other high risk employees include healthcare or laboratory personnel who collect specimens of suspected COVID-19 patients. So these are the folks who are doing the testing or gathering the materials that's needed to do that testing. And then medical transport workers, such as ambulance vehicle operators and EMTs who are moving known or suspected COVID-19 patients in enclosed vehicles. So you can see how that would create a particularly high risk of exposure. So this is OSHA guidelines and OSHA's definition of high risk and very high risk occupations. So in light of the executive order, what do? Which claims should we accept and which claims should we delay and investigate? So up until this time, there was a lot of analysis and thinking that went into this, which claims to accept, which claims to delay. The executive order actually makes this a little bit simpler. Claims should be accepted if the employee is in a job classified as high risk or very high risk of contracting COVID-19 and they qualify for the presumption. So for example, a nurse who was working in a high risk occupation at a hospital, for example, dealing directly with COVID-19 patients within 14 days at the hospital, and within 14 days of that last shift, he or she is diagnosed with and tests positive for COVID-19 themselves, that workers' compensation claim should be accepted. It's pretty much the end of the discussion because the presumption applies. It's a presumption of injury. Their job presented a materially higher risk of exposure and contraction of the disease. Therefore, the claim should be accepted. End of discussion. And in fact, in his remarks about this law, this executive order, that's exactly what the governor said he wanted to accomplish. And in that sense, the order does accomplish what he set out to do. Now, of course, the order is broad and covers every employee in California. So there are certain claims that can be delayed. And if a person is covered by the presumption, they've worked within the last 14 days, but not in a high risk occupation, maybe in a moderate or low risk occupation. In those situations, those claims can be delayed and investigated. And that investigation can include determining whether the risk of contracting COVID-19 for that individual and what they've been doing in the time frame up until their test result or their diagnosis, what was their likelihood of contracting this community-wide communicable disease outside of work? That's the question, and that's what can be done within that 30-day period to delay the claim and investigate it. So it really will come down to, does the presumption apply and are they in a high-risk occupation? So this is a question that we get a lot from employers and have since the beginning of this crisis, is should I offer a claim form to an employee who becomes infected? And we had one set of advice up until May 6, 2020. Now our advice has changed a little bit. Well, maybe not a little bit. Because now we say generally yes, if the employee is covered by the presumption or is in a high risk occupation, a DWC-1 claim form needs to be offered. So if you have a high risk employee, that was our advice before this executive order. If the employee fit within one of these OSHA high risk occupations, offer them a claim form if they contract or are diagnosed with COVID-19. Now, we've broadened that to say that if the presumption applies to the employee, then they also should be offered a claim form. So the employer has, and the reason for that is because Labor Code Section 5400 puts the burden on the employer to offer a claim form within 24 hours of knowledge of an injury from any source. So if an employee tells you, hey, I've been diagnosed with or I've tested positive for COVID-19, and you don't know anything else other than this employee will fit under that presumption because you know, for example, they were at work at your facility or office or place of business within the last 14 days, within the time frame of the application of the executive order, or that employee is in a high-risk occupation, for example, healthcare, then you offer that employee a claim form because you have knowledge of an injury, at least a potential injury. As to all other workers, so people who have been working from home all this time, or people who are not in the high-risk occupation, people who don't qualify for this statutory presumption, and they are in a moderate or low-risk occupation, which most employees are, the vast majority. As to all those other employees and all other workers, so long as current medical information continues to indicate that COVID-19 is a risk to the general population, employers are now required to affirmatively offer those workers who contract the disease or are diagnosed with the disease with a GWC-1 workers' compensation claim form or to pay workers' compensation benefits. So if the employee asks for a claim form, if they call up and say, hey, I've been diagnosed with COVID-19 or I have become infected with it or I've tested positive, can you give me a workers' comp claim form? I'd like to file a claim. You give them a claim form. If an employee ever asks for a claim form, give them the claim form. But the important thing here is whether the employer has a duty to reach out to that employee and offer the claim form. And this is our best advice on that situation. There's a couple of important cases to consider. These are particularly relevant to that large group of employees who are not covered by the presumption because of the circumstances, because the presumption is limited. These cases are still relevant to those employees who are not covered by the presumption. The Supreme Court has said that if an employee contracts a disease while employed or becomes disabled from the natural progression of a non-industrial disease during employment, this will not establish a causal connection to work. And the court has also said that an ailment does not become an occupational disease simply because it is contracted on the employer's premises. Now I put that one in bold because that's directly contradictory to this executive order. Well, the executive order will override the case law because it's very specific. But again, it's limited in time and it's limited to circumstances. Now it does cover all employees, but only in limited circumstances. So if the presumption is applicable to a particular claim, this case law does not apply. If the presumption is not applicable or after the executive order presumption expires, then this case law becomes relevant again. So which of these presumed compensable claims should we deny, or should employers consider denying? Even if the presumption does apply, employees who are in jobs that are not classified as high risk or very high risk of contracting COVID-19 by OSHA, the claims can be denied if the employee fails to cooperate in the investigation. Now this is going to be big because there's only 30 days to act. There's only 30 days to deny the claim. It's already developing that the employer in these situations is going to have to act pretty quickly to get statements from that employee, or at least to interview that employee by telephone to verify the facts of whether the presumption applies or not. Like, for example, have you worked at the location of the employer? Did you actually go into work? Was it within 14 days of the diagnosis? So on and so forth. So those kinds of questions are going to be important to find out, obviously, but some employees don't cooperate. They won't return a call, or they won't, maybe they're not in a position to answer those questions within 30 days. You'd be surprised. Maybe it's very likely the employer will need to get a medical release from employees, especially if their diagnosis or testing comes from a non-workers' compensation physician or setting. Generally, if a workers' compensation physician or the occupational medicine clinic conducts the testing or does the diagnosis, the employer will have access to that information for purposes of determining whether to accept or deny the claim, or their claims administrator or insurance company will have access to that information. So it's pretty transparent. But in this situation, the employee may be going into their own family doctor and say, you know, hey, I don't feel well. And the doctor may say, well, I need to test you for this disease. And they do. Well, the employer does not have automatic access to that information. It's HIPAA protected. And the only way for the employer to get that information is for the employee to sign a HIPAA medical release. And then the employer can go get that positive test result from the family physician and the medical reports that accompanying it, and make a determination as to whether the presumption applies. Well, if the employee doesn't cooperate in that investigation, there's a long line of cases that say that failure to cooperate is a good basis to deny a case, especially when the employer's time limit to get this done is only 30 days. If there's 90 days, we can do a lot more within 90 days. We could even set a deposition of the employee, or depose the doctor, or subpoena records, or do a whole bunch of things that a 30-day time frame doesn't allow for. So this is, I suspect, going to be quite a few cases denied simply for failure to cooperate. The claim can also be denied if the employer can prove, because the employer has the burden of proof, that the workplace exposure was not the medically probable cause of contracting the viral infection in that case, thereby rebutting the presumption. How does the employer do that? And am I out of my mind, or can we really still deny a COVID-19 claim? Yes, you can. You can, and no, I'm not out of my mind. Yes, you can deny COVID-19 claims, even presumed compensable claims, because the presumption is rebuttable. Sorry, I keep saying it, but it's an important point. Is not a conclusive presumption. It can be rebutted and the claim denied where it was more probable that the claimant contracted the disease while off duty or away from the workplace, especially if there is a known non-industrial cause, such as an already infected household member or other community-based source of infection. You can find that out by interviewing the employee and getting more information. It's possible the employee was involved in community-based activity that exposed them to COVID-19 to a greater degree of risk than they would be exposed in their low hazardous occupation or moderately hazardous occupation. As with any delayed workers' compensation claim, medical records can be reviewed and statements taken to rule out this off-duty contraction of the disease. So that's what the employer has to do. The employer has to go through these steps to deny a COVID-19 presumed compensable claim in good faith. And it can be done. Here's another point that maybe this is the last time I'll say it today, but it's an important one to say at least a couple of times, or more than a couple of times. If the presumption applies, the claim can only be denied within 30 days. That's a remarkably short period of time. It makes sense for the employers to act on any COVID-19 claim, whether or not the presumption applies in the employer's opinion, within 30 days, if at all possible. Because we want to avoid the appearance of a late denial. So who pays for testing? Okay, so now we know that there's COVID-19 testing has to take place at one time or another. It has to take place when the presumption is initially invoked, or it has to take place later on to verify the initial diagnosis, or else the presumption does not apply, and presumably we don't have a compensable COVID-19 claim. So first of all medical treatment under this executive order, including COVID-19 testing, is subject to utilization review and independent medical review. Nothing in the order changed that, or at least not that I could find, or not that any of us in our firm could find. So the utilization review process can be used not only for COVID-19 treatment, but for the testing, because testing is a form of treatment. If the COVID-19 claim is accepted, then the testing, or if the employer elects to do so, the testing should be covered by workers' compensation if it is certified by utilization review. If the claim is delayed, the testing can still be conducted by workers' compensation up to $10,000. That's Labor Code section 5402C. And even the most expensive COVID-19 tests aren't going to cost anywhere near $10,000. 5402C has been around for a while, and it says that in a delayed workers' compensation case, the employee can receive medical treatment certified by UR until that claim is denied. So it's probable that if the claim is filed and the testing needs to take place, either the initial testing or the testing to follow to verify the initial diagnosis, it can be covered by workers' compensation. There's a sick leave offset for this executive order, which I think is pretty important. What it says is that the employer, if the employer has paid sick leave benefits that are specifically available in response to COVID-19, then those benefits are an offset to temporary disability or labor code section 4850 pay that would otherwise be due and payable. And presumably this includes the Family First Coronavirus Response Act paid leave. There's a few different forms of paid leave in that act. Presumably that leave, which the employer has already provided, will be an example of a sick leave offset to this. This has to be sick leave specifically available in response to COVID-19. So it could be this Family First leave. It could be, for example, one of our local counties elected to pay their furloughed employees. I believe they classified it as sick leave for 3 weeks after the furlough, if they couldn't work from home. So if their job didn't permit them to work from home. So those folks, that benefit, that leave benefit, which was paid specifically in response to COVID-19, would be an offset to temporary disability or 4850 pay. So where an employee does not have such sick leave benefits specifically granted under COVID-19 related circumstances, the employee in an accepted case or a presumed compensable case that's accepted shall be provided with temporary disability or 4850 benefits, if applicable, from the date of disability. So that's the same as every other workers' compensation case. What this provision does is it prevents employees from getting paid twice. It's never a good idea for workers' compensation cases to pay people twice or double for their time off. Creates a disincentive really for the system to operate properly. So the offset for COVID-19 makes sense, and the fact that in the absence of sick leave offset, regular benefits are due makes sense. It's consistent with case law and the existing statutes. Now, the indemnity benefits that we've just talked about, temporary disability and 4850, they have to be certified by a physician. That's usually true in all workers' compensation cases, and it's nice that this executive order spelled that out. So that certification from a physician certifying 4850 or temporary disability, well, there could be an MPN provider or a pre-designated physician. It could be the physician in the employee's group health plan. Any one of them can, under this order, can certify TD or 4850 pay. So it's a little bit broader than the standard workers' comp case in the sense that the employee's family doctor in their group health plan can certify TD or 4850 pay in this circumstance. If the employee does not have a designated workers' compensation physician or group health plan, maybe their job doesn't include health benefits, maybe they're a part-time worker and don't have a coverage, then the employee should be certified by a physician of the employee's choosing who holds a physician and surgeon license. This is also a little bit more, now the first paragraph in the slide is a little bit more broad than your standard workers' compensation case, and the second paragraph is a little bit more narrow because the physicians, under the circumstances of the employee choosing a physician to certify their temporary disability or 4850, it has to be actually a doctor holding a physician and surgeon license. So it can't be, for example, a chiropractor who can serve as a primary treating physician in the standard workers' comp case, but in this case, and a chiropractor can certify employees for temporary disability, for example, but not in this instance, not with this executive order. It has to be a physician and surgeon licensed doctor. So temporary disability has limits under the statute. Some people have interpreted this to limit the period of temporary disability under this law, or the period of 4850 to 15 days or to 45 days, but that is not how we read this executive order. What we do see in the executive order is that to qualify for temporary disability or Labor Code Section 4850 pay, under the order, the employee must be certified for temporary disability within the first 15 days after the initial diagnosis, and recertified for temporary disability every 15 days thereafter for the first 45 days following the diagnosis. So that's a burden that's put on the employee in these situations, that their temporary disability has to be regularly recertified. It's not open-ended. In your standard workers' compensation case, it's generally acceptable for a treating doctor to certify for periods of time longer than 15 days. But in this case, the order specifically limits it to these 15-day increments, at least up to the first 3 certifications for the first 45 days. After that, arguably, it would default to your standard workers' comp process. And it's our opinion that this executive order allows for the full period of temporary disability and 4850 benefits allowed by law. So if a person becomes seriously ill from this COVID-19 or its consequences, which some people do, a sizable amount of people do, or else we wouldn't be in this pandemic and we wouldn't be subject to this, these circumstances, those people may in fact run through a full 104 weeks of temporary disability as allowed by law. So we don't see this executive order as limiting that exposure to 104 weeks of temporary disability or combination of 4850 pay and temporary disability in every case. One thing that's different about this executive order is that it eliminates the 3-day waiting period for temporary disability benefits. It does not apply. So a person can have 2 days of temporary disability. There is no 3-day waiting period. So there are other indemnity benefit limits. If the employee tested positive or was diagnosed prior to May 6, 2020, that's the day that this order became effective, the employee must do the following 2 things: obtain a temporary disability certification by May 21, 2020, documenting the earlier period of temporary disability, and be recertified for temporary disability every 15 days after for the first 45 days following the diagnosis, like everyone else who falls under this order. So May 21, 2020 is a day that should be diaried basically for every claims adjuster who has one of these cases, because that's the deadline for temporary disability certifications for any employee who is covered by this presumption and was diagnosed or tested positive for COVID-19 prior to May 6, 2020. As I read this and we read this, if they don't come up with that certification by May 21, 2020, then they're not entitled to temporary disability benefits under this executive order. If the illness causes permanent rateable impairment, so again, there are some people, a sizable percentage, who have serious permanent health consequences and which could produce rateable impairments that are permanent in nature. And those folks may be entitled to permanent disability awards, as every other workers' compensation claimant may be entitled to. The executive order leaves in place apportionment of permanent disability under Labor Code sections 4663 and 4664. Other presumptions, like the heart presumption and the cancer presumption, cannot be subject to at least all elements of apportionment. Labor Code section 4663E specifically precludes apportionment of permanent disability to, for example, cases where the cancer presumption applies. Well, this particular presumption does not is not put under Labor Code section 4663E. So apportionment to non-industrial conditions or pre-existing conditions which could contribute to that permanent impairment will be apportioned and not the responsibility of the employer under this statute. So for example, you may have someone who develops pneumonia as a consequence of this illness. In their case, it's a presumed compensable illness, perhaps. But maybe the pneumonia was they had previous bouts of pneumonia. Maybe their lungs are compromised from prior injuries and illnesses that were not related to their work. To the extent that the permanent disability is due to those pre-existing or non-industrial factors, that will be apportioned out. Death benefits apply. Again, this is a bad disease. It wouldn't be the subject of so much of our attention if it wasn't, and it has a high incident of death, unfortunately. And death benefits under workers' compensation do apply. If a person has a presumed compensable COVID-19 infection and their claim is accepted and benefits are being paid, and the person unfortunately dies as a consequence of the disease, their dependents could be awarded up to $320,000 or more if they have young children, plus burial expenses and plus possibly other benefits that apply to safety officers in the event of death. These numbers turn depending on the number of dependents that the person leaves, but clearly death benefits apply under this presumption. There's one change under this presumption law, and that is that the death benefit that would otherwise be payable to the Department of Industrial Relations Death Without Dependents Unit is waived under this order. So generally, if an employee passes away from a work-related injury or illness, but they leave no dependents, the employer still has to pay death benefits to the state of California. Well, that provision is waived under this order. So those death benefits would not be payable to anyone if that person dies without dependents. So this brings us to the question of, is the cure worse than the disease? And by that I mean the negative consequences of COVID-19 and this presumption of injury or illness in the workplace. The negative consequences of this order may give pause to some employers who are considering restarting operations or directing staff to return to work on premises, at least until the order expires on July 5th. So for example, if an employer is debating whether to restart a factory or order staff who have been working from home to come back to the workplace, this may give them pause because so long as that factory remains closed, so long as those employees who have been laid off are not rehired, or so long as staff can continue to work from home, and so many employers are advising them to continue to do so until after July 5th, because that same employee working from home is probably, well, almost certainly not covered by this presumption, or that same employee who has been laid off and is not working is not subject to this presumption, because they're not actually in the workplace. So this order, one of the consequences of this order may be to give, and we're hearing this directly from employers who are considering, it's certainly giving them pause, because this order does create an increased risk of restarting that business. There are, just a whole host of risks associated with restarting business operations and having staff at work, obviously, that long predated this order, premises liability issues, and so on and so forth. This is just one more risk that employers have to consider with regard to employees who are returning to work in the workplace, or businesses that are considering reopening with employees in the workplace. Another risk, which is an interesting one, is that this order could create exposure to third parties. And this becomes relevant with business liability exposure. So for example, if an employee who is covered by the presumption develops COVID-19, and before they realize they have it, they go home, they expose their family members or household or their community members to this illness, and then those members of the community or the household contracted the disease arguably traceable back to that employee and their presumed compensable underlying illness, which is the responsibility of the employer under this statute. Now the employer has potentially liability to those third parties, especially if they become seriously ill. So you can see that there could be a chain of events which creates even more exposure to employers as a result of this executive order. There are work from home implications. We've talked about some of them, the biggest being people who are working from home are probably not covered by this presumption if they have been working from home the whole time that this order is applicable and haven't gone into the workplace during that time. But what about those employees who are instructed to stay at home? So here's sort of the catch-22 that the employer is in. You know, maybe the employer says, well, I'm just going to keep all those staff who can work from home. We're going to continue to work from home until July 5th because I don't want them coming into the workplace. Because if they do and they contract the disease, it's presumed compensable. But keeping those employees working at home also creates a separate set of risks because the people who are working from home may be exposed to the pandemic from household members that they would not otherwise be exposed to because they're now in contact with those household members far more frequently. As I'm sure many of you watching this video are spending a lot more time with your household roommates, your family members than you had been before, because now you're spending, 24/7 with them. That additional time at home could create exposure to this pandemic that would not otherwise be present, and it can also create regular old workers' compensation injuries that would not otherwise occur. And I'll give you an example of some that have actually already happened. People are ordered to work from home to avoid contracting the disease. That's good advice, right? That's, everybody's recommending that. Every government level, from local up to the federal, up to World Health Organization, are recommending it. But most people don't have their homes set up in advance to work from home. And there's not been a lot of time for employers to help people get their workplaces ergonomically fit. So employees who are working from home end up tripping on wires that are haphazardly rigged up to a spot where they can work and plug in their laptop so it doesn't crash while they're in the middle of a project. All of a sudden, there are additional hazards associated with working from home that may or may not be covered by workers' compensation benefits. Those cases will depend on whether the employee injured themselves while working at home as opposed to while living at home. So it can be very difficult to investigate those claims where the employee is both at home but also in the workplace at home. So what should employers do? That's a tough one because there's so many things going on right now in relation to this. Only a tiny fraction of which we have covered in this program. CalGov HR is a great organization for those who are not familiar with it. CalGov HR. They have, if you go to their website, they have just a whole host of information that employers can use for how to address the COVID-19 crisis, the special benefits that are applicable, only some of which we've touched on outside of workers' compensation. But I do want to talk about a couple of things that are relevant for workers' compensation related purposes and for generally for keeping a safe workplace. Number one is that the employers are always obligated under the OSHA Act to maintain a workplace that is free from recognizable hazards that are causing or likely to cause death or serious harm to the employees. So that's the basis by which employers are really mandated to do their best in this crisis to keep workplaces safe and free from contamination of this virus, keep people socially distanced when they are at work, complying with the social distancing as much as possible when they do get back to the workplace. For all those reasons, not only does it make sense for our society to do that, but it's also obligatory to employers under the OSHA Act. And it's consistent with the shelter-in-place orders. Another thing employers can do is remember their EAP program if they have one. Employee assistance programs have a lot of useful tools. There's a lot of employees and employers who right now are anxious and facing financial and childcare challenges. It's a turbulent time for a lot of people. An EAP program can offer help not only with mental health intervention, but also with financial planning and other help. Even childcare coordination is something I believe that EAP programs sometimes offer. So it's a great benefit. Don't forget about it. If you have it, use it. Another benefits that are available are employers should be aware of and using all the other benefits besides workers' compensation that are available. So there's lots of employees who may not be covered by this presumption, but maybe facing all kinds of difficulties because of coronavirus. They're having to, their kids are home from school. They have maybe sick family members that they're having to take care of. They have spouses that may have been laid off. There are other benefits that these folks may qualify for completely outside of workers' compensation, including the Family First Coronavirus Response Act, paid leave, short-term disability benefits, and other benefits that are already offered by the employer, state disability income, and other government entitlements. So employers should be mindful of that, and at the outset, reach out to employees with that information. So that's really the meat and potatoes of this presentation today. There's probably just a whole host of questions that you may have. As a reminder, if you have a question, you want an answer, email your closest RTGR law office, and there they are right there. We don't make our email addresses very complicated. So for example, our Los Angeles office is at las@rtgrlaw.com. If you send an email there, it'll go to our partner in the Los Angeles office, our senior partner there, who, like all of our other partners and all of our senior attorneys, are very well versed in this law and are happy to answer your question. If that person doesn't know the answer, we have a COVID-19 task force of all these senior people, and we're constantly in communication with each other. He or she will bounce that question off of the team, and we will get back to you with our answer. If it's a question we haven't had before, we will post it on our blog, in our frequently asked questions page, or on our page devoted to this executive order on our blog. If you go to rtgrlaw.com to our blog page, you'll find you'll find probably the question that you have yourself and the answer to that question. And if not, email our office. So as I said at the outset, RTGR Law tackles the most challenging claims and controversies long before this crisis came about in the fields of workers' comp, civil subrogation, and employment law. It's important to us that employers can continue to do their mission. Many of our clients include public agencies who provide benefits and services to the public. Many of our clients include hospitals and grocery stores who are at the front lines of this crisis. We're very proud to represent those employers. We're very proud to represent job creators and people who are building communities and moving California forward. You can stay updated. We put out a newsletter. It doesn't come out too often, but we will put very useful information, including we had an update on the coronavirus within days of it becoming relevant in California and how to deal with it in our initial newsletter right after that. If you send an email to the newsletter at rtgrlaw.com email, it will you'll be added to our list, and it's again, we're not going to spam you. It's just a periodic newsletter that goes out with useful information. You can, as I said, go to our blog for not only more information about coronavirus and COVID-19, but also other webinars that we have available in addition to this one. And if you follow us on LinkedIn or Twitter, we usually post the same updates on those sites as well. Continuing education credit for claims adjusters is available. You send an email to, once again, newsletter@rtgrlaw.com and put CE credit in the subject line, and we will email you a certificate of attendance for claims adjusters. And your email to us at that newsletter site will include the, that will be our confirmation that you participated in the program to its very end. And we will save that email so that we can prove it should we be audited. And we will send you a certificate that you can keep, and thereby documenting your continuing education time. If you would like a copy of this PowerPoint in a PDF format, email newsletter@rtgrlaw.com and put something to the effect of executive order PDF, and we'll send you the PDF. Thank you very much for participating. It was a pleasure, and good luck. Please stay safe, stay healthy. Hopefully we all come out of this and have relatively normal lives soon enough. Thanks a bunch.